Is the Majority Leader, Mr. Turzai.
Thank you very much, Mr. Speaker. Without question, our civil litigation system needs significant common sense reform. People are tired of having decisions second-guessed in a court of law, and people are tired of having to spend significant dollars defending baseless suits and spending numerous hours in depositions and gathering documents. They are tired of being subjected to the stresses of litigation. This amendment essentially eviscerates the negotiated reform of joint liability. It eviscerates it in the sense that it basically, by adopting this amendment, makes the reform, the underlying reform, inapplicable. The expansion of the doctrine of joint and several liability, to respond to the maker's points, is one of the tools used in today's litigation environment that in fact fosters lawsuit abuse. The origins of joint and several, I would offer, are different than set forth in the previous maker's remarks. The doctrine of joint and several liability has actually expanded significantly once it was imported from the common law in England. It is far different today than it was originally established. Joint and several liability initially applied to common law to shared torts, situations where multiple tortfeasors injured a plaintiff by acting in consort or breaching a common duty. No joinder of parties was allowed if the parties did not act in concert. The rule, however, was expanded to concurrent torts or torts where independent torts occur at the same time to inflict an injury. According to a 1994 Wisconsin Law Review article, joint and several liability is the deep pocket theory because it encourages plaintiffs to seek out defendants of minimal, if any, culpability, but maximum financial ability, and then add them to the suit to bankroll the expected judgment. According to a 1987 Dickinson Law Review article, the rule of joint and several liability has the effect of singling out industries, hospitals, and professionals. These are the deep pockets that are most likely to have the resources to satisfy a damage award. Plaintiffs' attorneys regularly pull in anyone remotely connected to a case, particularly a defendant with a lot of money, and if the plaintiff can prove that person is even 1% at fault, the defendant could be forced to pay that total judgment. Let's be honest, joint liability reform is about defendant versus defendant versus defendant, and about the tort system that penalizes parties brought in as defendants. It is not about the plaintiff's relationship with the defendant. By putting forth an amendment, it sounds nice, but the whole goal of the amendment, of the Greenleaf Amendment as offered here, is to eviscerate or make the joint liability reform null and void. That's the point. Opponents argue that there's somehow an urban myth. In practice, let me assure you it's not. Any attorney involved in civil litigation, from the plaintiff or defense side, if talking honestly to you, can tell you exactly how the doctrine works day to day in litigation. A judge calls a settlement conference and eyes up each of the attorneys. He asks each of them not one, but two questions in determining how to fashion a settlement. What's your potential liability? And what's the likelihood that the plaintiff can collect from you? How much money do you have? The harder it is to get money from a defendant, the lower the amount typically paid by that defendant in settlement. But the easier to go against the deep pocket, the more the party will be looking to be paid, will look at to be paid a settlement amount, even if his, her, or its liability is minimum. That's the way the system is played, and no one questions it from within. As a legal scholar has noted, there is a high level of unpredictability in the court system that is compounded by joint and several liability. Cases routinely go to juries on thin evidence and tenuous theories of liability, and juries are not effectively policed and tend to assess minimal liability as a matter of course. If you're in the suit, I'm going to give you a percentage. No actual liability becomes a nominal 10% liability in the eyes of a jury that turn becomes 100% responsible for damages under this joint liability. Inflated settlements absolutely occur as a matter of course because of that unpredictability. As my colleague from Westmoreland County indicated, the tort system we have in place is designed to deter negligent action. In joint liability, what occurs is you are picking up risk for somebody else's negligent actions or omissions that you cannot predict. It's not fair. You should be able to control your negligent actions or omissions and be held responsible for them, not another defendant's. As I said, this is about defendant-defendant, not plaintiff-defendant. And keep in mind, as a Cornell Law Review article put it, it is a sense of injustice that activates the tort process. Corrective justice is individualized, and it is bound to promote a system of deterrence. Joint liability does not do that. It promotes social insurance, and that is not what our tort theory is based upon. We went with a compromise, folks. We went with a compromise that other states have enacted. We said if you're up to 60% as a defendant, then you should only be responsible for your share. If you're 60% or above, then you can be found for the whole 100%. As I said, this amendment eviscerates that compromise in this negotiated reform. We're behind other states in enacting that. Both New Jersey and New York have similar liability reforms on joint liability, and many states actually have eliminated joint liability in total. Keep in mind that Pennsylvania enacted comparative negligence in 1978. And in 1978, guess what? We abrogated common law. We abrogated it. And when we abrogated it, we said that we're going to apportion amongst the defendants what their liability is. Now, I will tell you, in the decision that addressed that statute, that upheld it, the Chief Justice said, look, I think the legislature, he chastised the legislature for not eliminating joint and several liability, as other states did, when it enacted the comparative negligence statute in 1978. He said it is not for this court, but rather for the legislature to re-examine this language if unfortunate results such as this are to be avoided in the future. This is a Supreme Court Chief Justice from the other side of the aisle's party. We are doing that here today with the underlying bill. If we pass the amendment, we eviscerate that. The fact of the matter is, many of us have voted upon the underlying bill in 2002 and in 2006. Significant numbers of the other side's leadership voted for the exact language of the underlying bill. For the exact language of the underlying bill. 5 of those members on both the 2002 vote and the 2006 vote. I think these are good people. There are policy differences. We have twice understood what the underlying bill is, and we understood the compromise at play. We purposely adopted a compromise from New York and New Jersey, and this amendment eviscerates that. I must end on this note. I think that the discussion today and the debate today has been very civil and very rational. The only line of debate I must say, and I do take some offense and I apologize, was the gentleman from Philadelphia. To intimate that somehow we're a criminal or guilty by being against this amendment or for the underlying bill is not fair. I don't think it was true back in 2002 or 2006 when members of the other side voted for the underlying bill, and I do not think that is true today. I do not think that is a right allegation, and I do not appreciate the hyperbole. There can be significant policy decisions, but this is the underlying bill has the exact same language that was passed into law in 2002 and 2006 with votes from both sides of the aisle. That is just the case, and I do not feel like I'm a criminal or am I guilty by voting against this amendment or being for the underlying bill.